Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. We have heard from the 5th Circuit Court of Appeals, federal court. Sorry, I just hit record and my neighbor just decided they were going to cut their grass. We're going to do the best we can because there's painting going on next to my studio, so I can't record there either. But we were waiting for a federal court to give us a decision today, and while that still may happen, one popped up that we didn't. I don't know. They can happen at any time, but we weren't really expecting this one. This is the Vanderstock case. Sorry, it got loud. I had to pause it real quick. Let's get into this case. So a lot has happened in this Vanderstock case. The plaintiffs were Jennifer Vanderstock, Michael Andren, Tactical Machining, Firearms Policy Coalition, and then the federal court let others jump in as well. The federal district court, the 5th Circuit. There's been a lot going on. So the first was that the case was vacated. It was just deleted, saying it was unconstitutional. The ATF overstepped their grounds, then they acted on outside of their capabilities, and the judge vacated it. And then the government appealed directly to the Supreme Court to try to stop that, and the Supreme Court said, yes, we're going to keep the rule intact while it makes its way through the courts. And that's, I mean, it sucked and it pissed us all off, but it's something to be expected because they want to see cases progress the way they're supposed to. So where are we now? Well, today a court, the 5th Circuit, just came down and dropped a decision that I think it's important we understand, because these judges say some things in here that will anger some and will also explain a lot to get us to understand why they're doing what they're doing. And in this process, they're shaving down the amount of people who were protected by the injunction. It was to manufacturers and their customers. But now the judges are saying that's changing now. Here's the decision on the screen, and it came down about an hour ago while I was at the bank. And this is a 3-judge panel, and it says, the government's motion to vacate the district court's injunction is granted in part. The ATF promulgated a final rule that, among other things, changed the long-standing federal definition of a firearm frame or receiver. A group of plaintiffs brought a lawsuit challenging 2 provisions in the final rule. The district court held that those provisions exceeded ATF's statutory authority and vacated the entire final rule. The Supreme Court stayed the district court's rulings insofar as they vacate the final rule. 2 of the plaintiffs, manufacturers of frames or receivers regulated by the final rule, then asked the district court for injunctive relief pending appeal. The district court enjoined the government from enforcing the challenged portions of the final rule against the 2 plaintiffs and their customers. The government has now asked us to vacate the district court's injunction. We agree with the government that the district court's injunction sweeps too broadly. Injunctions that afford relief to non-parties are potentially problematic. And it appears the district court's injunction sweeps too broadly insofar as it affords relief to non-party customers, meaning people who are not part of this lawsuit. They're not named plaintiffs. That is particularly true because the government has been adamant in both writing and at oral argument on this motion that it will not enforce the final rule against customers who purchase regulated frames or receivers and who are otherwise lawfully entitled to purchase firearms. Lawfully entitled? What the frick? It's not an entitlement, it's a friggin' right. Of course, if circumstances change, the district court is free to narrowly tailor injunctive relief to meet the changed circumstances. But as things stand today, the government is correct that the injunction cannot extend to non-party customers. But we disagree with the government that the district court's injunction as to 2 plaintiff party manufacturers directly conflicts with the Supreme Court's determination that the government should be permitted to enforce the rule as to everyone while this appeal proceeds. We have 3 reasons. First, the Supreme Court limited its stay to the global relief afforded by the district court's vacator order. Here is what the court said in its August 8th stay order. Application for stay presented to Justice Alito and by him referred to the court granted. The June 30, 23 order and July 5, 23 judgment of the United States District Court for the Northern District of Texas, insofar as they vacate the final rule of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, is stayed pending the disposition of the appeal in the United States Court of Appeals for the Fifth Circuit and disposition of a petition for writ of certiorari if such a writ is timely sought. Should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. The Supreme Court could have simply stayed the district court's vacator order and judgment without qualification. Instead, the court stayed them insofar as they vacate the final rule. Second, we cannot say that the district court abused its discretion in granting traditional, limited injunctive relief to two parties. The party plaintiff manufacturers would be irreparably harmed by being forced to shut down their companies or by being arrested pending judicial review of the final rule. The party plaintiff manufacturers are likely to succeed on the merits because the final rule is contrary to law, and both the balance of equities and the public interests weigh in favor of allowing orderly judicial review of the final rule before anyone shuts down their businesses or sends them to jail. We are sensitive to the fact that the government is irreparably harmed whenever its rules are enjoined. Still, the federal definitions of frame or receiver have endured for decades before ATF changed them in the final rule. ATF's desire to change the status quo ante does not outweigh the few additional weeks or months needed to complete judicial review of ATF's work. Thus, under these cases, we cannot say the government has shown that it is entitled to emergency vacator of the district court's injunction as to the two-party plaintiff manufacturers. Third, we are unpersuaded by the government's insistence that the district court flouted the Supreme Court's August 8th order. There is a meaningful distinction between vacator, which is a universal remedy, and an injunction that applies only to two named plaintiffs. The August 8th order considered only the first a universal vacator. The government points out that its briefing to the Supreme Court also raised in the alternative that the district court's universal vacators should be limited to the parties in this case, and that the court did not follow the alternative path. It is unclear that there is such a thing as an as-applied vacator remedy under the APA. So it is unclear that we should read much into the government's purported alternative. In any event, we think it best to read the order the Supreme Court issued rather than the one it did not. At the end of the day, we think four things are paramount. First, inferior federal courts must exhibit unflinching obedience to the Supreme Court's orders. Second, the court has directed us to be skeptical, if not altogether unwilling, to order universal relief that extends to non-parties. That's a little bit of a hint on what we're going to probably get on the pistol brace rule probably today. Third, insofar as possible, we should have orderly judicial review in which the status quo is maintained and the legal rules sorted without asking courts to make monumental decisions in short-fuse emergency dockets. Fourth and finally, courts should be able to review ATF's 98-page rule and the decades of precedent it attempts to change without the government putting people in jail or shutting down businesses. For these reasons, the government's motion is granted in part, the district court's preliminary injunction is vacated as to non-parties, and the government's motion is otherwise denied. So that means that if you were a customer that was covered by the frame and receiver injunctions, you are no longer covered. It is only the parties that are named, the plaintiffs that are named in the case, meaning they're part of this case, they have skin in the game. It's not going to be universally cast, this injunction, to their customers. In this court case, the government has said, we're not going to enforce this on people who buy these. So I don't trust the damn government, but they are on record saying they're not going to do it. So that is an update on the frame and receiver case. It's not the last step, so this isn't the end of the road. It's going to continue. This is just on the injunction part. It will continue on based off of its merits, and this three-judge panel just said the ATF is likely to lose this case as well. because the plaintiffs have met that part of the injunction that they're likely to succeed on the merits. So I will keep you up to date and keep yourself free, because we should have another ruling today, probably shortly, from the Fifth Circuit on the mock case pistol braces, because the timeline for Judge O'Connor technically ran out this past Saturday. So I will keep you in the know. Subscribe to this channel if you want to stay in the know. For some reason, and I talked to my YouTube rep about this at the Iraq veteran thing this weekend, the range day. YouTube goes through and tries to determine if you are a bot. And if you have not been watching a lot regularly or not clicking on YouTube a lot regularly, you might have been deleted as far as a subscription. So double check your subscriptions. Let YouTube know that you are an American who is interested in your Second Amendment. Like this video and share it. I will see you on the next one, y'all. Be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That is what the Second Amendment is for. It is not for hunting. It is not for shotgunning. It is not for skeeting, although that's all included in that right. That is not what it was there for in the first place. ATF be damned. I'll see you on the next one. Take care.